Good morning, everyone. This is Abby from the Tribal Law and Policy Institute. Thank you for logging on to today's webinar for Strengthening Tribal Response to Violence Against Native Women. We'll begin in a couple minutes to allow others to start logging in as well. Please note that the line will remain silent until we begin. Hello, everyone. Thank you for joining us today. This is Abby from the Tribal Law and Policy Institute. I want to go over some quick tips before we begin today's webinar. I know many of you have attended past webinars and are already familiar with the control panel, but here are a few reminders. Your control panel will show on your user screen. All attendees will be muted during the presentation. And once you call into the meeting line, make sure to enter your PIN number. Use the question box on the control panel to submit questions and any responses. To minimize, use the orange arrow on the top left. And then to follow along with the presentation, under the handout sections are all the documents that will be referenced in this webinar. Today's webinar is hosted by Strengthening Tribal Response to Violence Against Native Women, and is part of our Legal Resources webinar series, focusing on tribal protection orders today, with Kelly Stoner as our presenter, the Victim Advocacy Specialist with TLPI. And now I will turn it over to Lana Hunter to get us started.
Thank you, Abby, and welcome to everyone who joined us for today's webinar series regarding tribal protection orders. We want to just go over a few program highlights for the Strengthening Tribal Initiative for ending violence against Native women. We have a project with the Office on Violence Against Women, which allows us to partner with tribal technical assistance providers around the country. And the opportunity for us is to provide training and technical assistance to non-OVW grantees. So this training is free and allows us to provide on-site, over the phone, in person, or office, or resources, or webinars such as you are on today to tribes who do not receive OVW funding. If you are unsure if your tribe does not receive or does receive OVW funding, you can contact us and we can provide you with that information. We also have a number of partners who partner with us on this project, and this is expertise around the country as it pertains to victim advocacy, so community victim advocacy, understanding the legal response as it pertains to tribal protection orders, as well as the opportunity to provide and sustain shelter funding or emergency housing. So this technical assistance would allow us to provide you training on each of these areas. So today and our upcoming webinar is going to be on tribal domestic violence court in docket, and that will be for October 9 or 9th. And we want to ensure that we have an opportunity to highlight a lot of the legal issues that tribal communities or governments may be facing when dealing with tribal protection orders. So we have a number of national experts from around the country, including the Alaska Native Women's Resource Center. This is to ensure that we have Alaska-centered and specific information, because we understand the geographical as well as legal needs in Alaska. We also partner with the Tribal Judicial Institute at the University of North Dakota Law School. We also have partners at the Alliance of Tribal Coalitions to End Violence, and this is the 18 tribal coalitions located throughout the United States, as well as the Tribal Law and Policy Institute, of which the Strengthening Tribal Initiative is housed at currently. Within our Tribal Law and Policy staff, who you will meet today, Kelly Stoner will provide you the overview of tribal protection orders. And in order to ensure that we are victim-centered, we have also partnered with direct service providers from around the country. These are tribal programs located in the Seminole Nation of Oklahoma, as well as the Native Alliance Against Violence, which is a program, but also a tribal coalition, and the Amonic Women's Shelter located in Amonic, Alaska. This is to ensure that the training and technical assistance, materials, on-site resources, and information that we are providing is relevant for victims. So we have a great panel of direct service providers as well. The Tribal Law and Policy Institute provides a number of training and technical assistance resources, as well as housing this program. And today's presenter works with us at the Tribal Law and Policy Institute, Kelly Stoner. She's a victim advocacy legal specialist, and she is an attorney and comes from an extensive legal background. She's worked with advocacy programs throughout the United States, but specifically in Oklahoma with the Native Alliance Against Violence. And she was appointed as a judge for the Seminole Nation of Oklahoma from 2011 until 2019. So I would like to introduce Kelly Stoner, who will be presenting today's content. And Kelly?
Thank you, Lana. Thank you for that. And welcome to everyone who's on the line here, and those of you who are not on the line who might listen to this recording at a later time. So let's review very quickly the learning objectives that hopefully this presentation will implement. We're going to be talking about VAWA 2013, and for those of you who are out there who might not know what VAWA stands for, it's the Violence Against Women Act, a piece of federal legislation. This particular rendition of VAWA was rendered and signed into law in 2013. We're going to be looking at the slice of that particular federal law that deals with tribal protection orders. We're going to be discussing the judicial power. I'm talking about tribal judicial sovereignty to issue protection orders and to ensure that those tribal protection orders are enforced both in Indian country and outside of Indian country. We'll be discussing how maybe some best practices, if you will, on crafting or drafting your protection order, including the necessary language that's set out in that federal law, VAWA 2013, to implement or engage the federal mandate that protection orders are entitled to full faith and credit across the United States. And at the end, we'll briefly touch on some mechanisms for enforcing these protection orders outside of Indian country. That seems to be a regular theme as we move around across the nation. Many tribes are having difficulty getting their tribal protection orders enforced in state jurisdictions. So next slide, Abby. The benefit of a protection order, some of the purposes that a protection order, that drives a protection order, is that the protection order sets forth clear commands from the court. One of the sort of the basis, the grounding of a domestic violence case is that the batterer is using a variety of different techniques to control the victim's behavior. So by setting clear commands directly from the tribal bench, the tribal court is actually taking some of the power and control away from the batterer and putting some parameters on what the batterer can and cannot do. Also, protection orders are issued with victim safety in mind. That's one of the purposes of getting a protection order. Again, that protection order, the tribal judge is setting the parameters of what is acceptable behavior and is not acceptable behavior. on the part of the batterer. And also, a violation of a protection order is really focused on batterer accountability to the commands of the tribal court. In other words, if the batterer steps outside of this acceptable behavior, this command from the court, that the batterer will be held accountable either in civil court or in criminal court. Next slide. Again, moving into VAWA 2013, and protection orders. So this slide is a little text heavy. I apologize for that. But I'm thinking that some of you might want to use this PowerPoint as a resource. And so I really hesitate to list tiny little pieces of federal law out for you to view, because I want you to see the whole piece of it. So this is VAWA 2013's definition of a protection order. You can read this later, but it's very, very inclusive. It includes almost every type of order that is issued where one party is filing or requesting the court to act for protection, to protect another person. Notice that it includes temporary orders, final orders, orders issued by civil or criminal courts. Again, so long as the order is issued as a response to something that's filed by or behalf of the person that's needing protection. Next slide. Also included in VAWA 2013's definition of a protection order, it's really important to understand how inclusive, how expansive this is, because as I move across the nation, some tribes are issuing documents, orders called restraining orders. They're issuing a variety of, the orders will have a variety of different names. So I want you to know that if a party comes and files a request with the tribal court seeking protection, we're going to look at that order, but chances are it has a high possibility of falling within VAWA's definition of a protection order. And this also includes any child support orders, custody orders, visitation orders, kind of read on down through there, as long as, again, the order is issued by the tribal judge in response to a request for protection, either filed by the person needing the protection or on behalf of the person needing protection. And at the very bottom, I just wanted to let you know that's the citation to VAWA 2013, where I listed this definition word for word. So if you need to search that, you can actually search by that number and the federal statute will come up. Next slide. Now that we know what VAWA 2013 says about what is a protection order, and that broad definition we just went over, I want you to know that that applies to all jurisdictions, to state jurisdictions, to tribal jurisdictions. I think one of the things VAWA 2013 focused on is that when someone's needing protection and they're asking a court for protection, almost any type of order is going to qualify as a protection order. So let's talk for a moment about tribal court jurisdiction. This has been up and down across the United States with respect to whether tribal courts, tribal judges have the power to issue a protection order in matters involving non-members, so that's non-member Indians or non-Indians. So there have been cases going up and down, and I think VAWA 2013 focused on trying to give us a rule that we could follow. So again, this is federal law, and what this particular statute says is that a court of an Indian tribe shall have full civil jurisdiction. That's the kind of jurisdiction a tribal court utilizes in most instances to issue a protection order. They have tribes have the jurisdiction to issue and enforce protection orders involving any person. So now with this federal law, we have some clarity that tribes do have the power to issue protection orders in matters where the parties in front of the tribal judge may not both be tribal members. So the statute goes on because there's a limitation here, and I put it in italics so you can see it, that tribes have this power to issue protection orders involving any person, civil protection orders, in matters arising anywhere in the Indian country, that's one thing, or otherwise within the authority of the Indian tribe. So it's the matter that's leading to the need for protection must arise anywhere in Indian country. So if you're a reservation-based tribe, you know that's within the exterior boundaries of your reservation. If you're a checkerboarded tribe, or let's say a tribe in Alaska, perhaps that's going to mean within, if it's not on trust or restricted land, it's within the authority of the Indian tribe. And when we see that particular phrase, what it makes me think of is the United States Supreme Court cases that put limits on a tribe's civil authority, civil power, and again, that's going to include the power to issue a civil protection order. And there's going to be a test that has to be met in order for the tribe to have jurisdiction to issue those orders when the parties in front of the tribal judge include anyone other than a tribal member. So let's go to the next slide. Just a couple of definitions here, won't spend a lot of time on it, because these are some of the requirements of VAWA 2013 for the full faith and credit mandate. The tribal court must have personal jurisdiction. The tribal judge then is going to be asking questions about the defendant's contacts with the tribe, any visits, any tribal benefits, those sorts of questions to see how many contacts that particular person has with the tribe, and also the power to even issue the case. So in order to look to determine for each tribe a personal jurisdiction or subject matter jurisdiction, we're going to be looking to the tribal constitution of the tribe issuing the order and the tribal code of the tribe issuing the order. Next slide. Let's get back to this VAWA 2013 clarification of the tribe's power to issue a civil protection order over all persons in matters arising in Indian country or otherwise within the authority of the tribe. So those two Supreme Court cases I just mentioned earlier that restricted a tribe's civil authority in matters involving non-members on non-Indian lands. I know, isn't that something? We have to go to those fact patterns like that, and they get extremely complex. But any fact pattern outside of what's in that bolded language, this does not apply to. So in other words, if you have non-members on trust land, high possibility this case doesn't even apply. If you have non-members on unrestricted lands, fee lands, even within the reservation, we're unsure whether this law applies. So I want to just give you the test really quick. Here are the two cases it came from. And we really sort of in the field refer to this as the Montana test. What you see following the name of those cases is the volume, the reporter, and the page number, and the year that the case came down and was published. So you can actually sort of cut and paste the case name and those numbers after it, and it should bring the case up for you to review. Next slide. Here's the Montana test. And again, this is limited only to non-members on fee land, and the tribe is in Indian country, and the tribe is attempting to exercise jurisdiction over these non-members. And that includes non-Indians. We're talking about civil, the power to issue a protection order. Either one of these prongs indicates, if you can meet the test, either one of these prongs indicates that the tribe can go ahead and exercise that civil authority. And particularly relevant in these protection order cases, to demonstrate that the parties entered into a consensual relationship with the tribe or its members through commercial dealing, contract leases, or other arrangements. There's arguments to be made that if a party, non-member or non-Indian, marries a tribal member or enters into a consensual relationship with a tribal member, that may give the tribal court jurisdiction to issue the protection orders, or the conduct threatens or has some direct effect on the political integrity, economic security, or health and welfare of the tribe. If you've even taken a look at the national statistics with respect to violence against Native women and their children, particularly domestic violence committed against Native women and their children, there is no doubt that domestic violence threatens and has a direct effect on both the political integrity, the economic security, and the health and welfare of the tribe and its members. I want you to think about if tribes are having difficulty getting their protection orders enforced, then this activity definitely has an effect on political integrity of the tribe. Think of numerous tribal police or BIA police calls for responding to these residents that are experiencing domestic violence. That there's money involved in all of those police calls. There's money involved if ambulances are called to the scene, and definitely those statistics there's just basically no arguing that it doesn't. Domestic violence affects the health and welfare of the tribe. It does. So this is the test. Again, I think it's important for you to just sort of remember, anybody other than a tribal member, we're going to just at least consider whether this test might apply. Next slide, please. Okay, and this just is a slide so you could sort of contrast. If you were a tribal judge and you are issuing an order and you know this victim is most likely going to cross over jurisdictional boundaries, enter into the state jurisdiction, either to live or to work or to go shopping. If the tribal judge is sending the victim out with a protection order, is it enough that the tribal judge just says the tribe has jurisdiction over the subject matter and personal jurisdiction? Let me be clear. By VAWA 2013, that should be enough. But in reality, what we are hearing from some tribes as we move across the United States is state courts don't want to enforce tribal protection orders. State courts often will argue they're unsure whether the tribe had the power, the jurisdiction to issue the order anyway, especially in cases involving non-members and non-Indians. So to draft a protection order like this, to me, even though VAWA, if it's implemented correctly, this should be enough. I think that tribal judges are going to have to work a little bit harder here, knowing that this victim is relying on this order for protection. So let's go to the next slide. Now let's take a look at this. Perhaps this one's drafted a little meatier here. Now we get the tribal judge writing in the order that the tribal court has the jurisdiction to issue this protection order and the reasons why. And what we also see is the tribal judge issuing this order also citing back to the tribal constitution or the tribal code. So this is a much meatier paragraph that would possibly strengthen the enforcement response by outside jurisdictions when law enforcement says, wow, this court really, they've looked at their code, they've looked at their constitution, and hey, this violence occurred within their Indian country. So I think this is a really good example of a starting point for tribal judges to use in drafting their subject matter and personal jurisdiction findings. Next slide, please. The next thing that VAWA is going to require, in addition to subject matter jurisdiction, and again, this is to issue a civil protection order, and personal jurisdiction that we talked about earlier, is notice. Notice and an opportunity to be heard. This language absolutely needs to go into tribal protection orders for enhanced enforcement. And the notice we're really not sure what that notice means, but it must be sufficient to protect the defendant's right to due process. In other words, if I go in and I ask for a tribal court for protection order, and the tribal judge says, yes, we have subject matter jurisdiction, yes, we have personal jurisdiction, and what kind of notice needs to go to this defendant so that they know a protection order has been filed against them, they've received a written notice and usually a copy of that protection order, they know when the court date is going to be. Next slide. And they're given a meaningful opportunity to be heard. In other words, when this defendant, whether they're a non-member or non-Indian or even a tribal member, appear in tribal court, the tribal judge isn't issuing a command that the defendant can be quiet, has to be quiet, is not allowed to tell their side of the story. As long as there's an opportunity offered to that defendant and they've received notice of the hearing and a copy of the protection order, chances are that notice and opportunity to be heard, you can check that box and it's been met. Next slide. The question is, why are carefully crafted or drafted domestic violence protection orders so critical to victim safety? And this is a huge, huge issue. Let me just say that in state court, many, if not most, of the state court judges simply check boxes. The state court has subject matter jurisdiction. We have jurisdiction over the person, both parties. We've provided a notice and an opportunity to be heard to the defendant. They're just checking boxes, much easier. When it comes to tribal protection orders, despite VAWA's mandate that all protection orders should be treated equally, they should be respected, honored, enforced. That's not in real life what's happening. So we have to think about, well, what can tribal judges do then to promote the enforcement of their tribal protection orders everywhere in all jurisdictions? So I think drafting of the protection order is critical to the enforcement of the tribal protection order in state courts. It also promotes consistency of the protection orders across jurisdictional lines. It promotes victim safety, and a properly drafted protection order has remedies in it for the victim, these commands to the defendant that should be drafted so clearly and precisely that any prosecutor, any state prosecutor, any tribal prosecutor, when they're reading a police report or reviewing a statement, they can say, hey, very easy for me to think I can prove this beyond a reasonable doubt because the remedy is drafted very clearly. Next slide. The language that goes in the protection order is critical because if the protection order, the tribal protection order, doesn't contain the VAWA mandatory language, chances are that the state court's going to say, well, this doesn't look familiar, doesn't have the VAWA language, we're not going to honor it. Also, the language in the order, and I'm not going to go really into depth on some of these issues today, but I just wanted you to see how important the language is. The proper language in that protection order can also trigger a federal firearms prohibition, and there are federal laws that if the protection order contains certain language, it is a violation of federal law for the defendant to possess firearms or ammunition. And also, protection orders that contain certain language that have been violated, there are federal laws that say that the defendant can never own firearms again, ever, even if the protection order expires. So this language that goes in these protection orders is critical to victim safety. Also, a violation of the protection order can also affect child custody. It can affect whether later the perpetrator is charged as a habitual offender in federal court. So very important. Next slide, please. So the protection order should contain specific concrete language, much like the findings of subject matter and personal jurisdiction that we went over before, the notice information we went over before, and it needs to meet all the requirements that the tribal law says needs to be met to issue a protection order. So I want to put the tribal statutes in there. I would also put the VAWA full faith and credit cite to that federal law in there. And the language is, again, crucial, because if a law enforcement is called to a house, let's say, in Indian country, and the victim has a tribal protection order, if the tribal protection order language says, well, the parties should not annoy one another, or the parties can't contact one another, but it doesn't say anything more than that, and it wasn't the defendant that contacted the victim, it was the defendant's aunt that contacted the victim. Well, that's not technically a violation of the order. So we have to get really clear when we set these parameters for the batterer, or the batterer, believe me, will find the loopholes and begin to manipulate and control this victim through the loopholes in the order. Next slide. Again, this is just another example. We already went over this. This is the tribal court making findings about subject matter jurisdiction, about the personal jurisdiction, and where the acts occurred. Now, there needs to be another paragraph that talks about the notice and opportunity to be heard that went to the defendant, but this is a pretty meaty paragraph for a protection order. Next slide. One of the things I also advocate for, sort of the best practice for tribal judges that are drafting these protection orders, is that they make findings of fact. And what a finding of fact means is, to me, as a former tribal judge, it would mean that I've heard evidence, and some of the evidence I believed and some I thought maybe wasn't particularly credible. So I'm going to tell you what I believe meets the requirements of tribal law to issue a protection order in the first place. And once I make those findings of fact, and it might be if the petition for a protection order or the application for a protection order indicated that on July 4th, the defendant struck me as the petitioner with an open hand in the presence of several people. Then when I hear the evidence as a tribal judge, I'm going to say, oh, that was true. The defendant did strike you on this day because I've listened to all the evidence. That's very, very important to that victim later. If there are custody disputes, if there are wanting to dismiss or modify the protection order, the judge will look back and say, oh, this is what the tribal judge found. So these are the things the judge found to be very credible. Also, language, again, that really sets the parameters on that defendant or that respondent, and this would be the batterer. No more committing acts of domestic abuse against the petitioner. And again, I'm going to look to that tribal law to see how that domestic abuse is defined. And if I feel like I need to be more clear, I'm going to add some more to this. The respondent shall avoid the petitioner's residence or residence temporarily occupied. Now, these are really too loose for me. I would say these need to be really tightened up a little bit, because I think a respondent can wiggle out of these. Next slide. All right, and here's the notice that we've been talking about. Respondent was given notice of today's hearing by the Deer Nation Tribal Police Department. That's the tribe I made up. Proof of service is on file in the court file. Or if it's an ex parte order, the notice is going out with a copy of the petition. The respondent's going to see that he has a court hearing on September 20th, and so that and copy of that notice is going to go into the court file. So that's a notice and opportunity to be heard. Next. Be as specific as you can in the tribal protection order. Don't say petitioner, her children, say their full names and identifications. We don't want to put addresses in there if that compromises victim safety, but we want to put as much information in as we can. We want to say, instead of saying no contact in the order, something really specific like the respondent shall not come within 300 feet. That should be petitioner right there instead of respondent. He's not going to come within 300 feet of the victim at any time, and no contact with the petitioner or children, no communication directly by where the respondent's calling the victim or trying to talk with the victim through third parties, including family members. You can't text, you can't FaceTime, you can't do any of these things. So you have to get really, really specific. Next slide. Here, we talked earlier about the firearms language that can go in the protection order. I'm not going to spend a lot of time on this slide, but I wanted you to have the information. So this language that you see in the blue is what is required in a protection order if the tribal judge wants to engage the federal firearm statutes that deal with whether a respondent, a batterer, if there's a PO issued, whether that respondent or batterer can have a firearm or ammo in their possession. Next slide. More on the firearms here. And again, this is very convenient because one of the requirements of the firearm is that the tribal court has subject matter jurisdiction over the party, and notice an opportunity to be heard was given to the batterer, the respondent, the defendant, whatever you're going to call them. And those are the same pieces that need to be in to engage VAWA full faith and credit. Next slide. So now we've talked about the tribe's power to issue a civil protection order. We've discussed some best practices in drafting tribal protection orders to sort of close those loopholes that a batterer might have to manipulate that victim that might occur when a tribal court order isn't really drafted tightly enough so that a prosecutor, whether it's a state prosecutor or a tribal prosecutor, can actually prove beyond a reasonable doubt a violation of the protection order has occurred. So let's now talk about enforcing these tribal protection orders. Next slide. So tribes can enforce violations of protection orders, either protection orders that they've issued themselves as a tribe, or perhaps state protection orders. If a tribal victim got a protection order in state court, coming into tribal court to enforce that protection order as well. Tribes can, and this is over everyone, well, let me back up because we're going to talk about criminal prosecution. A tribe can, by civil contempt, force compliance with the protection order. It's really important to know, though, if a tribal judge is going to punish or force compliance, let's say, with a civil protection order, that the remedy or the order of the court is not to punish the defendant or the respondent. I'm just going to say defendant, so I can't keep having to say both words. But if the tribal court judge is trying to civilly enforce this protection order, there's been violations, the victim's complained, it's before the court, the tribal judge can only force compliance with the order. In other words, batterer, defendant, you're going to post a bond, you're going to pay a fine, we're going to make sure that we're going to hold that money and make sure that you're going to comply with this. If you violate again, you might forfeit your money. Civil contempt, it's not to punish, it's to force compliance with that order. Protection order violations can also be enforced through criminal prosecution. That's a crime, and many, if not most, jurisdictions all over the United States have some sort of criminal enforcement for violation of a protection order. Keeping in mind, though, we have some Supreme Court case law that indicates that tribes don't have, or they've been restricted. They still have it, but it's been restricted by Congress, the power to criminally prosecute non-Indians. non-Indians for crimes committed in Indian country. We are going to talk a little bit later about a federal law that has loosened those restrictions, saying, tribes, we know you've had this criminal authority all along, and we put restrictions on it. We're going to loosen the restrictions if you can meet some federal mandates, and we'll talk about that later. Criminal contempt, again, criminal contempt, if we're talking about summary contempt, that's something that's happening in front of me as a tribal judge. There's a lot of discussion about whether tribes have criminal authority for acts that occur right there in court in front of the tribal judge to criminally sanction a non-Indian. Some people believe yes, some people believe no. But again, I think it goes back to, as a tribal judge, I have to be able to maintain order in my courtroom. And if I have a non-Indian in front of me in a matter, a civil matter even, and if they jump up and start shouting and cussing, and if they, anything like that, totally out of order, I'm going to have an option. I can do civil contempt and put some civil sanctions on it. And at least there's some argument that this is an inherent power of the court, at least to maintain some sort of decorum in the courtroom, that also would have the authority to do something to the non-Indian in that regard. Next slide. So the enforcing jurisdiction, you kind of have to look at this chart. The issuing jurisdiction, and this is super interesting to me. The issuing, let's say it's the Deer Nation Tribal Court issuing this order. The Deer Nation Tribal Judge is looking at Deer Nation law to say, okay, to issue a protection order, this is who I can issue protection orders to. This is what the evidence has to show. These are the kind of remedies I can offer. And so the Deer Nation law applies to the Deer Nation issuing a civil protection order. When that protection order is taken to outside jurisdictions, those outside jurisdictions, according to VAWA 2013, must honor the order as it is written, even if tribal law allowed that victim to maybe address custody, and let's say the state won't allow custody to be addressed in a protection order. The enforcing court must enforce that protection order as it is written, but they will use their own criminal law. The state will use its own criminal law to punish for the violation of the order. Next slide. Okay, I already went over that, so let's skip that one. I'm sorry, I get ahead of myself a little bit. I've already done this one as well, so we'll move on to the next one. Okay, the advantages, like if I'm a tribal judge and I'm thinking, well, if I'm gonna, I've been notified there's a violation of the protection order, I'm gonna have to decide whether, this is it gonna be a civil or is it gonna be a criminal? And if it's criminal, usually the tribal prosecutor's bringing this before the judge. But to enforce civilly, there's some really stark distinctions from as opposed to trying to enforce it criminally. If it's a civil violation, the parties before the court, the petitioner, the victim, most likely, would just need to demonstrate by a preponderance of the evidence, that's just like 51%, slightly tipping that scale of justice by evidence to show there's been a violation of an order. On the other hand, if it's a criminal case, it's beyond a reasonable doubt. You've got the tribal prosecutor involved. A lot more evidence needs to be put forth for a criminal sanction to be issued by the court. Also, civil due process, and this is like the filing a petition, how many days notice, the defendant is the defendant going to respond to the petition, all of those processes of moving that case through the court system are sometimes lax. It's a relaxed sort of, we want you to follow the rule, but if you miss one rule, it's usually not fatal to your case. On the other hand, these criminal processes, when the prosecutor files the complaint or the criminal action against the defendant has so many days that the case probably has to be in front of the court for a trial. If you violate the criminal process, chances are the case might be dismissed. So there's going to be more severe consequences for failing to follow the criminal process. And that's set up because civil, usually the remedy is going to be a command of the court. It's going to be you better do something or not do something. In criminal, the tribal judge is looking at the evidence and say, if I find you guilty, you may lose your freedom here. So that's the reason for the distinction between the two. Next slide. Creative civil remedies. Here are, if you need to get creative and you haven't implemented special domestic violence criminal jurisdiction that we'll touch on in a few moments, and that's the federal law that is loosening the restriction on tribal criminal jurisdiction, and it allows tribes that meet the federal mandate to prosecute non-Indians who commit 3 crimes in Indian country. It's allowing tribes to, once again, pick that back up. And so creative civil remedies, let's talk about those first. I put a list there for you. There's actually an article out, if you Google it, it's Creative Civil Remedies for the Non-Indian Offender. And it's by myself, Kelly Gaines Stoner, and Hallie Bonger White. And that article, that law review article, sort of comes from a roundtable of people with, oh my goodness, so much expertise from all disciplines who work in Indian country. And they sat down at this table and they really reflected, discussed, and came up with some creative civil remedies that are being used in the tribal courts in which they work. So it's, here are a few of those. Next slide. Here are some more creative civil remedies. Again, I'm drawing on that law review article I just mentioned to you. Next slide. More creative civil remedies. This is a fascinating list. Tribes were getting super creative about how to hold non-Indians accountable in Indian country, because at this time, when this article was written, VAWA 2013, I don't believe, had come out, and there was no special domestic violence jurisdiction that a tribe, that restriction against the tribe exercising criminal jurisdiction over non-Indians was still in place. Next slide. So enforcement of protection orders using contempt power, we've already talked a little bit about that. Civil contempt before the tribal judge is my remedy against the defendant. Really has to be to force compliance with the order. If I mistake as a tribal judge and I begin to say I'm punishing, that's a criminal contempt. And if it's a non-Indian there, chances are if they appeal, they have a good chance of winning. Criminal contempt, again, it's going to be applied to criminal law. And so I'm going to have to look to the tribal code and say, when I bring a criminal charge, is the person entitled to a jury trial, and all of the things that go with criminal law have to be afforded to that defendant. Next slide. The power to enforce a tribal protection order over, this is Indian violators, and this means tribal members of the tribal court issuing the order and other members of federally recognized tribes. So we know there's a case here, I put the site for you, that tribes have criminal jurisdiction over all Indians who commit crimes in their Indian country. So if it's an Indian violator protection order, jurisdiction seems clear as it can be in Indian law. Next slide. This slide deals with the power to enforce a tribal protection order criminally against a non-Indian violator. This is where VAWA 2013 comes back in. It says that, in actual language of the federal statute, says that Congress recognizes tribal inherent criminal jurisdiction over non-Indians who commit certain acts, and these are the 3 crimes: domestic violence, dating violence, and protection order violations, if those tribes can meet the federal mandate, these requirements that are set out in VAWA 2013. So when I'm talking about this special domestic violence criminal jurisdiction here, as we move through the slides, I'm really focusing on protection orders, even though tribes that meet these federal mandates can exercise criminal jurisdiction over non-Indians to commit domestic violence or dating violence within their Indian country. Next slide. So non-Indians violating protection orders in Indian countries. We know that this, I'm going to call it SDVCJ for Special Domestic Violence Criminal Jurisdiction. It applies only if the violation of the protection order is the piece of that order. Again, drafting is critical. That protects the victim against violent or threatening acts, harassment. You can kind of look down there. The order was issued against the defendant. It's enforceable by the participating tribe, and it's consistent with the full faith and credit given to civil protection orders. And again, for full faith and credit, drafting those orders, the judge must make a finding that the tribal court has subject matter jurisdiction, the power to issue these civil protection orders, that there's jurisdiction over the defendant, and that thirdly, notice and opportunity to be heard on the protection order matter has been given to the defendant. Let's go to the next slide. All right, and the term victim also is defined to mean the person that is specifically protected by the protection order that the defendant allegedly violated. So I want you to pause for just a minute. Okay, the victim is asking me as a tribal judge for a tribal protection order. She's telling me she needs protection. She's telling me what has happened. And if the victim needs her children on that order, those children must be listed. If they are not listed, then I'm not sure that SDVCJ will apply to that, because it requires the victim to be the person specifically named on that protection order. And I think that's what I'm saying in the next line as well. Next slide, please. Some things that VAWA does not cover, the special domestic violence jurisdiction. It does not cover when the victim they're both non-Indian. If the victim and defendant are both non-Indian, that's probably going into the state court system. If the non-Indian defendant lacks certain ties, this is the only time we really need to sort of measure the defendant's ties to the tribal court that's issuing the protection order, and there I've listed them. The defendant must, and again, this is only in SDVCJ cases where you have the non-Indian as the defendant violating the protection order. Defendant must reside in Indian country of the participating tribe, be employed in the Indian country of the participating tribe, or be a spouse, intimate partner, or dating partner of a tribal member who resides in the Indian country of the participating tribe. So again, as a tribal judge, if it's a criminal violation of protection order, I want to issue some criminal sanctions over the non-Indian, hold that non-Indian accountable. I'm going to have to make findings and hear evidence that one of those contacts exists. If the act did not take place in the Indian country, it was a criminal act, it was violated in the state, and the victim comes back and says he violated my protection order, SDVCJ will not allow tribes to exercise criminal jurisdiction for a violation of protection order that occurred outside of Indian country. And this SDVCJ will not apply if the tribe has not chosen to exercise it and put these federal mandates in place. Next slide. Okay, and Lana, with that, it is 2 o'clock straight up. Do you want me to go over the resources, or did you want to do that, Lana?
If you would like to go over the resources, and then you can have the opportunity to pause questions and I will go over the remaining slides that request training and how to request training and technical assistance and locate or direct folks to our website.
Great. Okay, so Abby, if you could put us down one more slide, please. So as you all are, if you're not already, if you don't already have a tribal court, if you're not already issuing civil protection orders, I hope this has been helpful to give you some ideas about some of the issues that tribes are facing now as they're issuing civil protection orders and are attempting to get those civil protection orders enforced in other tribes or in, outside of Indian country in state courts. Let's take a look at some of the resources that we've put together for you here that might be beneficial for you. If you're interested in special domestic violence criminal jurisdiction, exercising tribal criminal jurisdiction over non-Indians who commit dating violence, domestic violence, or violating a protection order in Indian country, you can find a whole host of well-organized, well-written resources on that topic at this particular website. Next slide, please. If you are interested in gathering more information on drafting tribal protection orders, issuing tribal protection orders, enforcing tribal protection orders, here is a TLPI website for you. Here's a picture, a screenshot of that, and it will walk you through some best practices, some ideas, some things for tribal judges to think about as they're issuing these tribal civil protection orders to hopefully boost the possibility that outside jurisdictions are going to enforce that tribal protection order. Next slide. There was and is in some jurisdictions a project called, I believe it's called Project Passport, and sort of the movement towards this particular project was, again, to address the difficulties that tribes are having getting their tribal protection orders enforced outside of Indian country. One of the arguments that some states put forth is that tribal protection orders don't look just like ours. And so one of the things that's happening is that through Project Passport, it sort of walks you through some of the steps to determine if any changes need to be made to the tribal protection order and sort of working towards full faith and credit. Next slide. Some other resources, and we've put some live links on here for you. If you want to, you're just like, what? Jurisdiction, civil, criminal. There are some tribal jurisdictional charts on the TLPI website that are very, very helpful. If we have victims advocates out there and they're saying, well, confidentiality, we know it's tied to victim safety. We're getting confidential information put in our tribal court orders. We're struggling with confidentiality between service providers to the victim. There's a nice resource there. If you are in tribal criminal court, and this would hold true in I believe the majority, if not all, of the states as well. In a criminal case, victims have rights, and so if the victim in this domestic violence case, there's been criminal charges against the defendant for either violating an order or recommitting a new domestic violence crime. What are the crime victim rights that apply in your jurisdiction? And I can tell you that website right there contains, I believe, all of the tribal victims' rights statutes if the tribe has codified those and if those were available online. It will also contain all of the state and the federal victims' rights that are going to apply to each one of those jurisdictions. So that's a great website. We've already gone over tribal protection orders. And if you have sexual assault issues about protection orders specific to a sexual assault or sex trafficking, all of these resources here that we have listed are good places to go and get additional information. Next slide. Full faith and credit. This, again, is the concept, legal concept, where VAWA 2013 clarifies tribal jurisdiction to some degree, and also mandating that every jurisdiction in the United States for these protection orders, no matter where they came from in the United States, if they contain this language that we went over earlier, that they must be given full faith and credit, and they must be enforced as they are written. Here's a whole host of resources that you can go to learn more about that concept. Next slide. More, oh, here's the article. We actually gave you the link to that. Good. The creative civil remedies. If you're a tribe and you're thinking, well, you know, the special domestic violence criminal jurisdiction over non-Indians sounds great, but we're just not there yet. And so what we're most concerned about is issuing our orders and through civil remedies, holding batterers, all batterers accountable. Then the article will come up right there. Next slide. And this is my contact information, my phone number, and my email address, kelly@tlpi.org. And if you want to learn more about the Tribal Law and Policy Institute, you can click on that link. Next slide.
All right, Kelly, we do have one question, so we'll take a little pause here, and if anyone else has any questions, just let us know. We got one more too. So, Kelly, the first question is, may tribal law authorize ex parte orders of protection, as does Arizona law, that are enforceable under VAWA?
Is that the question?
Yes.
Okay. So I'm assuming they, can you read it to me again? I'm sorry. It sounded like a statement.
There's a little bit more at it. It's, so to clarify, did you say that a tribal court cannot take enforcement action concerning a violation of a tribal order that occurs off reservation? So that I understand jurisdiction is either geographic or based on relationship to a tribe.
Great question and great point of clarification here. I was talking specifically about special domestic violence criminal jurisdiction over non-Indians. And if the violation occurred outside of Indian country, SDVCJ will not apply over the non-Indian. If, however, now let's just take that's one chunk of it. But if we have possibly a tribal member who commits a violation of a protection order outside of Indian country, I do know and have read some tribal laws that allows a tribe to exercise criminal jurisdiction over that tribal member for crimes committed outside of Indian country. Now, that may be a little bit controversial, but I know I've seen the tribal laws, and I do think that one of the components could possibly be that relationship of the tribal member to the tribe. So that's one thing right there. I also want to say this. If you have a protection order that's violated outside of Indian country, oftentimes, as some of the cases that have come before me as a tribal judge, when I hear all of the facts of the case, in fact, possibly if there was a physical assault that occurred, the violation occurred outside of Indian country. But sometimes those acts continue and spill over into Indian country, especially through social media. If the order was drafted to prevent that sort of contact, I can oftentimes find certain acts spilled over into Indian country. So, but for that Indian, let me erase that. For the non-Indian who violated a tribal protection order outside of Indian country, special domestic violence criminal jurisdiction by that federal law specifically says tribes would not at that point be authorized to exercise criminal jurisdiction over that matter. Now, if you know what your Indian country is, because some tribes have very checkerboarded Indian country, so again, it gets extremely complex. And I hope I shed some light on that. And if not, if you could just ask the question again, because maybe I didn't understand it correctly. Next question.
That was the only question we received so far.
Okay. And if that person who asked the question wants to email me and have the dialogue that way, I'm at kelly@tlpi.org, and I'd be happy to.
Wonderful. Thank you, Kelly, for your expertise, your knowledge, and being so generous to share that with us today and our webinar participants. I just want to follow up with additional resources that we have. Kelly provided a number of resources as they pertain to law or legal resources or tribal protection orders. We also have additional resources located on our website that pertain to advocacy, specifically victim advocacy, as well as shelter, sustaining shelter, as well as providing either shelter through a program or setting up a coordinated community response within your community or a sexual assault response team. And as Kelly mentioned today, tribal protection orders are a very specific and expertise training and technical assistance that we can provide. So if your tribe needs further assistance, either in any of the areas that Kelly mentioned today, or as it pertains to jurisdictional, legal codes, she also mentioned constitutional, looking at the tribe's constitution, as well as understanding tribal enforcement or local enforcement of tribal orders. You can contact Kelly directly. She is one of our legal resource Indian law experts, as well as we have another colleague who is a professor at the University of North Dakota Law School, Michelle Rivard Parks. So we have a number of experts that would be able to answer your question. We're just going to hold quick. We have one more question, and then we're going to wrap up.
Kelly, this question is, would you recommend a PPO for Indian land in trust and one PPO for state area?
That's a great, all the questions are great today. Here's my thought on it, you know, and I really think that this is an opportunity to give the victim an option. Oftentimes, Native victims want to come to their tribal court for a whole host of reasons. I mean, you know, from comfort and having to go in front of people who understand your spiritual beliefs, your beliefs about raising children. When you go into state court, that's not necessarily a component that state judge might be interested in. That judge is sitting way up high and pronouncing all sorts of judgments. So I think that's a question that the victims need to be given options. With that being said, VAWA 2013, if jurisdictions would just enforce it, it's written. If your order meets these mandates, it's entitled to be enforced. You shouldn't have to get another order in a separate jurisdiction. But what we are finding is states have some pushback on this federal law that requires them to enforce this tribal order as written. And I don't know if it makes folks feel better, but I think some states, they don't want to enforce any protection order from anywhere, even if it's tribal or non-tribal. So we've got all sorts of layers of issues that have to be addressed. Now, with all of that being said, if getting an order, just applying real life here, what we're facing, if that makes the victim safer to get a tribal order and a state order, I'm probably going to say that's the best way to go. It shouldn't have to be done that way. But if what you are facing in real life, in real time, you think it's best for the victim, I would certainly give her that option. And you would know, the person asking the question would know better than I, whether you're dealing with pushback from the state in enforcing tribal court orders. And if you don't know the answer to that, ask your tribal victim advocate, because they can tell you, or ask your tribal coalition, because they will know. They'll have their finger on the pulse on that enforcement issue as well.
Thank you so much, Kelly. And if anyone has a follow-up question, please feel free to contact Kelly directly. And or if your tribe government who is on today, advocates, tribal advocates, tribal legal services, tribal court staff would like to request any training and technical assistance on any of the areas I've mentioned today, this information is available on our website at www.tribalresponse.org, or you could email tribalresponse@tlpi.org, or myself and our colleague, Bonnie Claremont. So that will conclude today's webinar session. Please visit our website, request training and technical assistance. And again, this is free to any tribes who are currently not receiving OVW funding. And again, I would like to extend a huge thank you to Kelly for sharing your information, your knowledge. Very few judges, whether it's state court, tribal court, federal court, really understand victim advocacy from the perspective of safety and understand the victim-centered needs. And I'm happy to say that Kelly really gets that and understands that. So I appreciate that so much from a victim advocate's perspective. So thank you, Kelly. Thank you, Abby, and thank you to each one of you for joining us today. And join us for our next webinar, which will be taking place on October 9th, pertaining to tribal domestic violence courts and dockets. Thank you so much.
Thank you.